Well, hello everybody. This is the Blackheath Philosophy Forum, and for years we've been organising public discussions on philosophical topics in the Upper Balloon Mountains, New South Wales, Australia. And because of COVID, we've been compelled to join the 21st century and start streaming some of our events. So this is the 7th event in our current series, and we're delighted today to have as our speaker Michael Sexton, Senior Counsel, the Solicitor-General of New South Wales, which is the top position in the Justice Department on the bureaucratic side, with the Attorney-General as the elected official. Michael's a graduate of law schools at the University of Melbourne and Virginia. He spent some years as an academic lawyer before taking up practice at the New South Wales Bar. And he was appointed Solicitor General in 1998. He's co-author of the Lexis Nexus Australian Defamation Law and Practice, and the author of several books on Australian politics and history. In fact, the very first book that Michael wrote back in 1979, I happened to buy and read at the time. It's called Illusions of Power, The Fate of a Reformed Government, which Michael was well placed to talk about, since he was the private secretary to the Attorney-General in the Whitlam government, Cap Enderby. And very interesting book. I read it at the time, and I pretty much agreed with it all. But the interest, it was a very interesting analysis of the constraints that operate on a social democratic reform government. And he put quite a bit of emphasis on the importance of trying to get control of the levers of the economy in a fundamental way, and talked about possibly the role of public ownership in that. That's the sort of debate we used to have when a lot in the Labor Party were serious about socialism. So, welcome, Michael. We're delighted you could join us today. I should say Michael has another book coming out this week, apparently, which is a collection of his essays over a period of quite a few years. And I might just show, it's published by Connor Court Publishers, and here it is. I'll just put it on the screen. You can order it at the Connor Court, CONNOR COURT Publishing House website, and that's it there. So thank you very much, Michael. And Michael's going to talk about the title of his talk is Free Speech versus Political Correctness, but he's going to be addressing a number of aspects of the free speech debate that go beyond the political correctness aspect, such as 18C, the operation of the defamation law, where he is a real expert, and various other aspects. So, with that, I'll ask Michael to address us. I'll get him on the screen. Where are we? Okay, I'll depart the scene. Oh, hang on, I'm doing this wrong. I should know how to do this by now. Okay, Michael, the floor is yours.
Thanks, Peter. I should start by saying that freedom of speech is, of course, and never has been, an absolute value. And I'll talk briefly about some of the legislative restrictions on it that are in effect a balancing exercise where there's competing values with freedom of speech. But I was going to start with Section 18C of the Federal Racial Discrimination Act, because that doesn't seem to me to be a case where there is a competing value. You might recall that what Section 18C does is to effectively make it unlawful to offend or insult various groups in the community. Now, I'm not suggesting that political and social debate should be conducted normally by means of offence or insult. But sometimes those sort of debates are quite robust, and sometimes there are people who are very sensitive and very easily offended. So I think proponents of freedom of speech have always considered Section 18C and its state and territorial counterparts to be a real problem in the area of freedom of speech in Australia. There are exemptions in all of those provisions, but it's for publications that were made reasonably and in good faith, that sort of terminology. That leaves a lot of subjectivity to courts or tribunals that might be deciding whether that's the case. And it's not much consolation to someone who's made these kinds of publications if they're finally vindicated after several years of litigation and the time and expense that's involved. So that's the chilling effect of these kinds of provisions. At one level, the contest over 18C was, of course, lost. The attempt to amend it under the Turnbull government in the Senate was unsuccessful. The government was unable to get a majority of the votes in the Senate. But at another level, I think the debate's been quite important because just quite recently, one of the proponents of Section 18C was complaining that there's been so much criticism of it that people are now afraid to invoke it and to use it in the way that it was used in a number of proceedings in the federal court. So it may well be that that even though the section remains on the statute book, that it has been quite truncated in its operation because of the public debate that took place over it over quite a few years. I won't go into the details of the state and territorial provisions, except to say that there are similar sorts of provisions at those levels. My favourite is the Tasmanian provision that prohibits conduct that offends, humiliates, intimidates, insults or ridicules another person on the basis of 14 different kinds of status, including marital status, relationship status, and family responsibilities. None of this, of course, is to say that incitements to violence against particular groups in the community should not be unlawful. As it happens, they always have been under the common law. But what the proponents of provisions like Section 18C say that they are doing is stopping hate speech in the community. But I think what hate speech has come to mean for many of those people is simply speech with which they disagree and that they don't want to hear. Now, if I just look at a couple of areas where there is a competing value with freedom of speech, and the restrictions that are placed on freedom of speech are an attempt to balance those two values. So Peter mentioned the law of defamation, which is an attempt to balance the freedom of speech on the one side and the protection of individual reputation on the other. The media has always complained that the laws of defamation in Australia place too many restrictions on what they can publish. There has been a reform process going on over the last couple of years in relation to the existing uniform legislation, uniform in all the states and territories. And I'm hopeful, because I've been involved in it, that before the end of the year, there will be legislation in all the jurisdictions that will make amendments to the legislation. And I can't, in a sense, go into detail in those at the moment, except to say that the media has made submissions over that whole period of time, and there's been consultation groups, and so there certainly will be changes to the existing legislation. And as I say, hopefully before the end of the year. The one subject that's been put off for a second stage for next year is what's to be done in terms of defamation law with the internet, with social media, Facebook, Google, etc. They're difficult questions. There's been quite different approaches taken in the US and the UK. When the uniform legislation came in Australia in 2005, they weren't live issues, but they are very much live issues now. So that hopefully will be addressed next year. Although one thing I can say is I think that even the 2005 legislation had an important provision which effectively precluded defamation actions by corporations and by government bodies, the thinking being that these could look after themselves. They usually have large public relations departments. They don't need the protection of the law of defamation. And that seems to have worked quite well over the last 15 years. Another area where there's a balance is the law of contempt, which is, again, freedom of speech on one side and the administration of justice on the other. Normally, not entirely, but normally what we're talking about here is publications that might prejudice a pending criminal trial. And people will probably be aware that there's been a series of prosecutions initiated by the Victorian government in relation to publications of the trial process involving Cardinal Pell, where there was a series of trials, and the question is, would publications about one prejudice the forthcoming trial? So that those are scheduled to be heard in the second half of this year. I was just talking about social media and the internet, and the sheer volume now of publications in that area means that in some ways the law of contempt can't operate as it did 40 and 50 years ago, when you might have a newspaper article that involved a current criminal trial and might prejudice the view of the jury. That was perhaps reasonably easy to address, but it's much more difficult now, as I say, with the sheer volume of publications and in relation to juries. And of course, juries themselves can go to the internet, although it's an offence for them to do so under New South Wales law. Third area where there's a balance is that of freedom of speech on one hand and national security on the other. I recall that this time last year, June of last year, there were 2 search warrants executed on media organisations in relation to national security stories that they published, one on News Limited journalist, and the other on the ABC at Ultimo. There were challenges to both those search warrants. The one executed on the ABC was upheld by the federal court. The one executed on the News Limited journalist was invalidated by the High Court. But there is a bigger question here than the fact of search warrants, because Australia, like all countries, has official secrets type legislation, and it remains an offence for a public servant to provide official material to a journalist, and the publication by the journalist may also be an offence, depending on the classification of the material and possible damage to national security. So that this legislation was amended in 2018, and there's a defence now for publication by a journalist if he or she reasonably believed that the publication was in the public interest. So this legislation hasn't really been tested yet. It represents an attempt to provide some sort of defence in some circumstances for publications, but there will always be this tension because most people accept that there are some areas in defence and foreign affairs where it would be damaging to the national interest if the material were made public. On the other hand, I don't know what Peter's experience was in Canberra, but mine was certainly that there was a lot of overclassification of material, and that there was certainly a tendency in the bureaucracy to treat some of the most innocuous things as secret, and therefore engage in the official secrets legislation. One final area, perhaps in this area, is again freedom of speech on one side. Under the terrorism legislation, the Federal Criminal Code, it's an offence for a person to advocate the doing of a terrorist act, which is defined to the sorts of things that you would expect it to mean. It just occurred to me that how this would work not so much in relation to events inside Australia, but to events outside Australia. If one were to, for example, to advocate violence, terrorist activity by one side or the other in, for example, the never-ending conflict in the Middle East, whether that would be an offence under the Australian legislation, because Australian legislation is designed to extend not just to events in Australia, but to events outside Australia. And there might be an argument that, of course, that in some of those foreign conflicts, there ought to be a freedom to advocate force by one side or the other. So I simply raise that as an issue. Now, before I'll stop dealing there, I think, with those formal restrictions on freedom of speech, and go to what I think is perhaps an even more serious problem for freedom of speech in this country. In the 1960s, the American economist and public figure John Kenneth Galbraith coined the term the conventional wisdom to refer to a whole series of views that were widely held and, as he would say, completely wrong, but that they were very seldom challenged because they were the conventional wisdom. I think we've got to a stage in Australia, this probably started, I think, in the 1990s, where on a whole range of subjects, and I just mentioned, for example, climate change, border security, reactions to terrorism, freedom of speech, where there's a consensus that's maintained by large sections of the media, by most teaching staff in universities, by major sporting bodies, literary festivals, the boards of large corporations, certainly I can testify, or legal professional bodies. Now some of those views may be quite supportable in whole or in part, but that's not really the point. I think the point is that it seems to me that no young person in our society could publicly espouse a contrary view if he or she wished to pursue a career in those areas that I've described. You might think this is exaggerated, but as someone who was once very familiar over a period of 10 years or so, teaching in 3 Australian universities with university common rooms, I'd be prepared to wager anything that a young aspiring academic who consistently contradicted this conventional wisdom amongst his or her colleagues would find their career prospects seriously affected. I'm not suggesting they would be dismissed, not if they had tenure at any rate, but certainly I think they would find their advancement seriously curtailed, and I think much the same could be said for young persons working in federal and state bureaucracies and in many large corporations. The question of how this political correctness or conventional wisdom has taken hold in Australia, not in the general community on the whole, but in all of these cultural and bureaucratic institutions which have such an important effect on people in the community generally. Question of how that has occurred in a relatively short space of time is, I think, something of an open question. I don't propose to really go into it today. I think the explosion of universities and the development of school curricula has got quite a bit to do with it. But as I say, it sparked, I think, a real degree of intolerance in some of those sections. I mean, if one takes, for example, the boards of large corporations, it might be thought perhaps that many of those don't want to contradict these views, but don't necessarily share them strongly. In some areas, of course, people do put forward these views very strongly. And it seems to me, going back perhaps when I was a student myself at university, and Vietnam was perhaps one of the largest political issue at the time, I still don't recall the same degree of intolerance on the part of those who were on the other side of political debates. Now there is a real feeling of intolerance for the views of those who contradict that conventional wisdom or those political correct views. It's true, of course, that the phenomenon exists as well in other Western countries, and particularly in the United Kingdom and in the United States. But I don't think it has permeated the centres of influence in our community to quite the same extent, and there are certainly, I think, more forces of resistance, if I can call them that, in some of those other countries. As I say, quite why and how this happened in Australia, and it may be that in a smaller society than, for example, in the UK or the US, it's been much easier to capture those centres of opinion and influence. And perhaps in a smaller society, there just isn't as much scope for diversity of opinion as there is in some other larger societies. At any rate, there doesn't seem to be any slackening of this phenomenon at the moment, and I'd like to be optimistic about the immediate future, but I don't think that there is much cause for optimism. Hopefully there will be a reaction at some point, and from time to time, in the case of, for example, of Section 18C, there was a reaction. It didn't get the legislation repealed, but I think it certainly did it a considerable injury and has limited its effectiveness. But more generally, it seems to me at the moment that that political correctness has taken a very substantial hold on Australian society. As I say, not in terms of the broad majority in the community, but certainly in terms of most of the bodies that control political and cultural discussion in this country. Perhaps I should stop there, I think, Peter, and there might be some reactions to all that.
Well, there have been. The chat window is filling up quite rapidly. So if you want to ask a question or post a comment, obviously the chat window is the way to do it. I would ask that you try to be concise and to be specific about what it is that you're asking or stating. So I'll begin by asking a few elaboration on a few points myself. Michael, you haven't so far referred to proposals for a Bill of Rights. I mean, people like, I think, George Williams at the University of New South Wales are inclined to argue that the right way to protect freedom of speech is via a Bill of Rights. I wonder if you could comment on that.
Well, I would certainly have a contrary view to that. I'd say two things about a Bill of Rights. One is that, to my mind, it's a very anti-democratic measure. What it does is to transfer power from parliamentarians to unelected judges to decide a number of political and social and economic questions. And that seems to me to be intrinsically unsatisfactory. There may be plenty of things to complain about parliamentarians, but the system that we have is that they make those decisions, and there's no reason to imagine that judges have any skills. I'll not be critical of them. Have any skills in those areas? They are questions for the elected representatives, not for the courts. And I'm not even just talking now about questions of freedom of speech, which is obviously a political issue, but in some of these bills of rights, which exist now in Victoria, Queensland, and the ACT, they have, for example, provisions for rights to housing and to education. The notion that these kinds of decisions, which are really decisions for budgetary decisions for governments, can be decided in the court strikes me as absurd. And if I just add one final thing, in any event, freedom of speech is a good illustration of this because, as in the United States, the First Amendment protects freedom of speech. All that does, you've got a general proposition to which you then proceed to advance towards all sorts of exceptions. And they're decided, and that's what's happened in the US, and that they're decided by the courts. So it's a very good example of how a political question is transferred from the parliament to the courts.
Yes, I think there's certainly a problem with a Bill of Rights that tries to mix up so-called positive and negative rights. So the positive right to housing or education is distinct from a right to not have certain of your activities, exercise of free speech, for example, being interfered with by the state. But would you sustain that objection to even a narrowly constructed bill, so that avoided altogether trying to get in all these positive rights and stuck strictly to preventing infringements by the state on freedom of speech. And I would have thought in the US, the First Amendment has been very effective over a very long time in at least closing off that source of infringement on free speech.
Well, of course, in some ways, the First Amendment has been effective, although there are many qualifications to it, and that, in a sense, they're decided by the US Supreme Court and not by the Congress, and that's one of the reasons why there's such vociferous conflicts over appointments to the Supreme Court in the United States, because the judges are deciding political questions, which everyone understands there. So that still seems to me to be, I would think, an overriding objection. But the other thing to remember about Australia in terms of freedom of speech is that that subject, for example, to those, I mentioned defamation, contempt, etc., you're always going to have some qualifications on freedom of speech. But subject to those in Australia, and dare I say, very unsatisfactory qualifications like Section 18C, otherwise there is general freedom of speech, subject to those kinds of legislative restrictions. We do have freedom of speech, and that's why I don't think you need a Bill of Rights to make that sort of provision.
Okay, thank you. Just if I could go to another area, the defamation law has been one of your main areas of practice. I just wonder whether it needs to be adapted significantly in the age of social media and the internet. I believe the federal government's conducting a review of that at the moment. I'm thinking, for example, of the so-called Volley Code, where a newspaper can be held liable if it has a Facebook page for things that are posted on that Facebook page for which it has no responsibility. If it's their Facebook page, they can be sued, which newspapers might be able to manage, but we had to think about this for our little exercise here because we were considering a speaker who we thought might be prone to saying defamatory things, and whether that could put us in jeopardy. Do you see that as an area that needs reform?
Well, it's certainly going to be an area that's going to be the subject, as I say, next year of a whole lot of consultations and discussions, and ultimately there will be legislative change. The court, you mentioned the Voller case, and the Court of Appeal upheld the decision, first instance, just a couple of weeks ago, and held the newspapers responsible. I'm not convinced myself that decision's correct, and I think the media organisations are going to try to take the matter to the High Court. But really, it's just one aspect of the whole area of internet and social media that it is going to be the subject of, as I say, a reform process or a change process next year, in the same way that every other aspect of the legislation has been looked at up till now. And as I say, all of that's just about finalised. But there are some difficult questions about what kind of liability should exist in, for example, I mean, if you take in Facebook, Google, and those kinds of institutions, they're different, of course. I mean, one's a search engine, one's a platform. But the question is whether you want to place the primary liability on, for example, the person who contributes defamatory material to Facebook, even though they may be difficult to find and even more difficult to get any redress against, or whether you want to place some liability on Facebook. But if you do, does that mean that people will stop using it, or that they won't be able to use it in the way Facebook won't be able to use it in the way they do at the moment. These are pretty difficult questions, I think.
Okay. Finally, I noticed that the debate about free speech in Australia, to some extent, the two sides, those like yourself who play for a strong commitment to free speech, and those who would qualify it rather more, who, for example, support 18C. When the two sides state their case, sometimes it seems like ships parting in the night. For example, George Williams had a piece in the Australian recently about free speech, which talked about various things, including, anti-terrorism laws and various other factors that might impinge on freedom of speech, but with no reference whatever to 18C. You got any general comment about the way this debate's ended up being structured?
Well, I think that I would say that that Professor Williams is, as I assume, someone who would be a supporter of Section 18C, and he's someone who, because we've had some debates between the two of us on occasions in public debates, he's someone who wants to see most of these questions in the courts, and rather than decided by the parliaments, and so that I would say that in terms of freedom of speech, that he has a reasonably restricted view of freedom of speech in my terms, at any rate. So that, but as you say, and I think I've said this publicly on occasions, it's one of the problems about the debate, and this was true over Section 18C, is that it's very hard to get any kind of response from the other side. You find very few persons who come out publicly and said that Section 18C is a good thing. There are some, but it's a relatively small number. But there's quite a lot of people who subscribe to that view, and they feel, I think, that they don't have to say anything because they think that the opponents of Section 18C won't be able to have it removed. And to that, they were certainly right about that. But as I have said before, I think that the persons who raised 18C and criticised its operation, I think they did have an effect.
Okay. Well, we might go to the chat stream. We've got some comments by Stan Giss, which are really comments. I think Stan has a question at 4:18 in the chat stream, so I'll go to that when we get to it. Anthony Carr asks, does the subjectivity required to determine what is offensive speech inevitably lead to the politicisation of the judiciary?
Well, I would say it's one thing that would help to politicise the judiciary, in the sense that there is a lot of room for, as I said, for subjectivity in something like Section 18C. First, as to whether it is offensive or insulting, and to whom, and then whether you can get to any of those defences, whether it's reasonable, in good faith to have said it. These are precisely the sorts of questions, I think, that you'd like to keep out of the courts, if possible. Now, of course, the courts often have to make judgments, but ideally not, I would say, in relation to political questions, which this is classically a political question.
Okay, Enrico Brick, I trust we can canvass some of the philosophical issues and arguments rather than have a principally legal discourse. Discussion of the underlying principles justifying restrictions on free speech. Well, we had a pretty good canvassing of that in the first couple of talks with Jim Allen, but I thought it important, given Michael's very extensive legal background on issues that bear on free speech, to hear a bit more about that. But I think Michael did touch on some of the philosophical issues when he got onto talking about political correctness after he discussed the formal aspects. Michael, did you want to add anything to that?
Well, only that I said at the very start that freedom of speech is not an absolute value, and my view of the philosophical discussion in this area would be what sort of competing values you want to allow to restrict freedom of speech. If you're going to start from the proposition that ideally, although it's not an absolute value, unless there's some reason to restrict it, that you would start from the proposition that you wouldn't do that. So you can have a lot of argument, of course, about what the competing values are and how much weight they should be given. As I say, if you take an area like defamation law, then some people would say that the press ought to be entitled to publish material which is damaging to someone's individual reputation, even though it later turns out to be false, if there was a public interest in that discussion taking place. Now, to some extent, there's a provision in those terms in the existing legislation in any event, but it's been rather narrowly interpreted, the media would say, by the courts. But that's the sort of discussion that you inevitably get to in this area.
Thinking, Peter, so the Jehovah's Witnesses and Mormons have the right to knock on my door and preach religion if I choose to listen, so I assume if I knock on their door and preach atheism, would that be offensive even if they listen? Actually, I haven't seen the Jehovah's Witnesses or the Mormons for ages. They seem to have gone off the radar screen. I don't know quite. Do you want to comment on that?
Well, as I say, I think in terms of preaching, I suppose, and from in either direction, I suppose, there shouldn't be anything. It shouldn't be offensive in legislative terms, at any rate. There's
no legal issue about it, presumably, knocking on somebody's doors and trying to convert them to atheism.
No, I don't think so. I mean, people would shut the door, I suppose, if they don't want to engage in those sort of discussions.
Philip Lambert, distinction between free speech and freedom of speech is more than semantic. Free speech in the right of assembly and freedom of speech where defamation laws relate to the content of that free speech.
Well, freedom of assembly there is an association there, and we've just had quite a few discussions about freedom of assembly in New South Wales in the last couple of weeks. Again, you get to the notion, if you talk about a Bill of Rights, and they usually contain a provision about freedom of assembly, but again, those general words don't take you very far. Question then becomes, is the traffic going to be obstructed, and what kinds of limitations would be placed upon freedom of assembly, so that it involves, someone pointed to the philosophical questions. It involves competing values. When I talk about traffic, I mean it's persons' freedom of. There's a notion of movement there in the community that can be restricted by some person's assembly. So again, to some extent, there's certainly a similarity of issues.
Stan, yes. How does one peacefully protest against the government without having their representatives shut them down, then threaten defamation when speaking out about that?
Well, defamation shouldn't be a problem in terms of criticising governments, because I think I explained that governments aren't able to bring proceedings in any event. Now, it's true that individual politicians can and occasionally have brought proceedings in defamation. I must say that I myself, but I'm not speaking for the government or for the defamation reform process, but I myself have always been attracted by the public figure defence in the United States, under which it's necessary for a public figure, which includes, of course, politicians, to have to establish malice if they're to be successful in a defamation action. Having said that, that has in the US largely led, as you would have in Australia in these kinds of actions, to an examination of in a journalist, for example, their sources and the research that they've done and so on, so that you're not going to get away from that kind of inquiry. But really, if one's in the area of political debate, criticism of governments and politicians, as long as it doesn't, for example, it's obviously a problem to impute corruption to an individual politician and not be able to demonstrate the truth. But in a general way, criticism in the course of political debate shouldn't be a problem in the area of defamation.
Simon, a question for both Mr. Sexton and Mr. Baldwin at the end is, where does intention fit in? Well, I suppose the malice issue to do with defamation would bear on intention, wouldn't it?
That's right. But in general, intention doesn't play large.
It's going to crop up in the 18C cases. Do they try and get into what did this person intend in saying that?
Well, one of the problems, perhaps about Section 18C, is that intentions irrelevant. But the real problem is that whatever one's intention in making a statement in that sort of area, that oughtn't to be an element of any kind of inquiry. The starting point, I would say, is that a statement that might be offensive ought not to be unlawful, and it doesn't matter what the intention was. It may have been intended to be offensive in one sense, but that doesn't seem to me to really take the matter any further. Most times, I don't think the kinds of statements that have attracted legal proceedings that they have been intended to be offensive. They've been made in the course of political debate. But inevitably, as I think I mentioned, some people are very sensitive and some people are easily offended.
Anthony Carr, should we look at the definition of treason?
Well, treason is not something that comes up very often, I think. Was traditionally, I suppose, the notion of trying to overthrow the state and overthrow, of course, under our English system, overthrow the monarch. I don't think there's been a treason trial since the end of the Second War in England, when 2 or 3 persons, one of whom was William Joyce, Lord Haw, were executed on the basis of the assistance that they'd given to the Germans during the course of the war. So I don't think it's alive. I don't think it's really a live issue. But if one were having a general review of those kinds of statutes, it probably would be. It might be useful to consider how it operates in the modern context, if at all.
Right. We've got a few here that are comments rather than questions. So I might treat those as comments in the stream. I'll move on to the next thing that looks like a next question. Here we go. Philip Lambert, is there any defence legally or ethically in making statements that are patently absurd, inaccurate, yet still offensive, e.g. Dutton's asseveration that there had been no slavery in Australia?
Well, I would say that those sorts of statements shouldn't be subject to any restriction. It's perhaps a good example where it's been made by a politician. It's open to be disagreed with. It's a question for public debate. It just seems to me, and this is the problem with Section 18C and the similar sorts of provisions at the state and territorial level, which I might say those state and territorial ones have very seldom been invoked. But the problem is that they simply stifle public debate, and I don't think they serve any other useful purpose.
So, how do you feel about the Andrew Bolt case? Now, you might want to. I don't know if you want to get into that.
Oh, well, I need to say I've said this publicly, that it's not necessary to. I never met Andrew Bolt, and it's not necessary to agree with everything that he says to say that he should be able to express his opinions. I say subject to obviously the law of defamation and national security and those kinds of questions. And I would say that the federal court proceedings in which he was found to have contravened 18C, well, by definition, I don't think that 18C should be on the statute books, and I don't. So I think that those sorts of proceedings are quite undesirable. And as I say, that there have been other persons who've expressed views, for example, the proceedings about the question. For example, I mean, one example that's used on occasions, well, what's to be done, for example, about people who deny that the Holocaust took place? Well, it seems to me to be an absurd view, and it's disproved by any amount of historical material. But I don't see that that someone who expresses that view should be the subject of legal proceedings under Section 18C.
Here we have a statement that you might want to comment. Freedom of speech is not a political issue. I don't know whether that Stan is saying it oughtn't to be a political issue, or whether, as a matter of fact, it's not a political issue. Anyway,
it's a political issue to me. The question of what people should be able to say in public in our society, that I would have thought it's classically a political issue.
Okay, Simon's asking about Andrew Bolt again. Why do you say freedom of speech is a political issue? Well, we already addressed that. Andrews Hex doesn't like Andrew Bolt. Noted, Andrews. So where do we get? Let's go to philosophy and critical thinking. The exemptions for defamation seem just as vague as 18C's. Chilling effect can be to defamation. Legal costs and stress of defamation cases exist. Can you explain how these are analogous?
Well, for two reasons, I think. One is that I don't think there's a competing value with Section 18C, whereas protection of reputation, I think most people would say is a competing value. The question is how much weight you give it. There are, of course, a lot of legal difficulties in applying the defences in the law of defamation, but nevertheless, I mean, I just take one example, which is the defence of comment or honest opinion, as it's put under the current legislation, where the theory is that if you set out the facts in relation to a particular matter, and then you express an opinion on them, for example, you say this politician has voted in the Parliament in this way, and I think his or her behaviour is utterly disgraceful. Well, that's a classic comment offence under the law of defamation. Now, one thing that's important, I think, to understand about the law of defamation, at least in all of the non-internet areas, is that most of these cases involve large media organisations, cases that get to trial. Because of the amounts of money and resources that are involved, sometimes on both sides, but certainly in the case of media organisations, you're going to have any amount of esoteric legal arguments about the provisions of the legislation. You probably can't avoid that, I think, in an area where you've got large amounts of resources involved. This is true for commercial litigation, for example, insurance claims and so on. And even in the family law area, when there's a contest, there's a great role for the lawyers to play, and there will be a lot of legal arguments. So once you get to court, you have to accept, I think, that there's going to be that this is what's going to happen.
All right. Stan Gisk asks WikiLeaks, and a lot of question marks.
WikiLeaks really raises that national security question, I think, as to what was the impact of some of the material that was released. I mean, I've never examined it. My impression was that a lot of it was relatively innocuous, and I mean, the notion, for example, that countries spy on each other and record their leaders' comments, etc. That can hardly be, you might think, surprising. On the other hand, if there's agents in place in a foreign country who might be put in great danger by publications, that would obviously be another matter. So the point about WikiLeaks, I think, is it really depends on the nature of the material that was released. It was in such a large volume that you would have to consider it, I guess, in different categories. No doubt the Americans were very upset by this, and of course are tending to pursue Julian Assange if they can. So at the moment, of course, he's facing extradition proceedings in the UK, and there I think they're still continuing at the moment.
Andros, is not more important than political correctness the perpetual political incorrectness of the military-industrial complex to maintain dominance over populace? See Murdoch and Andrew Bolt. What do you? Any response to that?
Well, I mean, it's a comment that really, in a sense, goes to who's going to exercise power in society. There's no doubt that in all Western countries, including Australia, there are institutions that are extremely powerful, and there are, in some ways, a counterpoint to the governments in those nations. One thing we know, I suppose, is that even elected governments can't sometimes do things that they'd like to do because of the forces that oppose them in the society. I don't mean oppose them by military means or by armed resistance, but just simply by the resources that they have at their disposal, that they're able to make it too difficult for governments to take action in certain areas. But that's part of the political system that we have. I'm inclined to quote Churchill's view that democracy is the worst of all systems except for all the others. We're certainly not going to achieve perfection in the immediate future.
Cherie Wax, do you support whistleblower protection legislation in light of the Bernard Collaery case and many others where national security hasn't been raised, but people have been fired, etc., over exposing wrongdoing?
I haven't looked at, I don't really know about Collaery's case, which is a case not in New South Wales, but in the ACT. Well, it's a Commonwealth prosecution, but I think all jurisdictions now have whistleblower legislation, protection legislation, and certainly that's true in New South Wales. There's always going to be practical problems, I think, for someone inside an organisation, whether it's a government or a private one, who wants to make allegations against the senior management and the persons who are running the organisation. They're going to obviously encounter a lot of difficulties, but the legislation is designed to try and protect people who want to take those allegations to those in authority. And in New South Wales, there are avenues, for example, the Independent Commission Against Corruption, to which matters can be referred. I don't suggest that all these systems are perfect either, but there has been a lot of work done on legislation to protect whistleblowers.
Simon asks a question for you both. If we have a right to know, do we also have a right not to know?
A right not to know what?
I don't know quite what that means. I don't think anybody's ever challenged anybody's right not to know something. Anyway, Patrick Cowell, what is the biggest barrier to free speech, the government or the corporation?
Well, I think I suggested in terms of political correctness that this has become a phenomenon of both government bodies and many large corporations as well. I suppose both governments and corporations would like to restrict debate about their shortcomings or their alleged shortcomings, but and that's why I think it's important to putting aside even that political correctness problem, why legislation in the various areas that I talked about, why it needs to maximise the freedom of speech that can take place. As I say, they're competing values, and they will be given weight. But that's the question: how will that balance be? How will that balance be struck?
I think it's actually my sense. If you look at the US, we talked about the First Amendment, and which is the strongest, I suppose, constitutional protection for free speech in the world. But I think this issue of the behaviour of corporations in the age of social media has become quite critical, because what's happening on in the US is that entities like Twitter and Facebook have recently gotten into the habit of, in effect, censoring certain types of content they don't like. And the First Amendment really has no applicability to that. And yet these entities are the gatekeepers to the digital public square, so to speak, where most political discourse is going on these days. It seems incredibly significant. I mean, people like Senator Ted Cruz in the US have brought up the thing called the Communications Decency Act over there that requires in order to be exempt from being sued for defamation or whatever, Facebook and Twitter need to not be publishers of content, which, you know, once they start censoring stuff, they tend to get into. But yeah, it just seems to me that the First Amendment could be turned into a dead letter if, you know, the discourse that goes on in the digital media is subject to pretty much arbitrary censorship.
Well, it's a good point, and there are difficulties in this area. I mentioned earlier incitements to violence and advocacy of terrorism. I doubt that anyone would want those to be available on, for example, Facebook and Twitter. But the problem is that once you say that these kinds of dangerous views can be censored, it's easy to move along and to start to censor political views that you don't like, or that perhaps the majority of the community don't like. And that's, I keep coming back to, I won't keep referring to it, but the problem with something like Section 18C, which is just a very useful example in this area, is that it's an attempt to restrict public discussion in certain areas where I would say there's no countervailing values that are available. It doesn't cover incitements to violence, for example, or any of those kinds of things. It deals with matters that are offensive, which one would think is a very low threshold in terms of public discussion.
Okay, what do we got? Michael. Yes, imbalance of political power is part of our democracy, but should not vested interest be prevented from running government against the common good?
Well, the easy answer is certainly yes, but I suppose the question is how. One way in which powerful interests perhaps are less likely to be successful in a contest between them and the general well-being of the community is if that contest is publicised, and that sort of pressure is brought to bear on politicians. But I think under our system, those kinds of contests are inevitable, and it naturally politicians and governments are susceptible to pressure from, as I say, powerful groups in the community, and I don't see that can ever be eradicated, but obviously the more open the debate is on those kinds of questions, perhaps the more likely it is that you will get the better outcome.
Question for you both, legally and politically. Do you think the rules in society and speech generally, the more rules, I think, the greater the likelihood we'll violate them?
Well, I suppose inevitably, the more rules you have, the more likely it is, just like the traffic code, that someone will violate them, and that's why one reason why I would say that that while you're inevitably going to have legal areas like defamation and contempt, that you want to try and minimise, I think, these restrictions on public debate, and so you don't want to be setting up new and novel restrictions, which of course, until relatively recently, you didn't have those kinds of regulations.
Philosophy and critical thinking. My understanding of 18C's purpose is to protect vulnerable minority groups that do not have the same reach to challenge bigotry. Would this be a competing value?
Well, I understand the argument. It just seems to me that on the question of offensiveness, that there isn't really a competing value. It's just simply too low a threshold. All individuals and groups in the community can be subject to offensive statements and offensive comments. I think that, as I say, I don't suggest recommending them on any kind of general basis, but I don't think that it's, in my view, it's useful to single out ethnic groups for that kind of protection in comparison with other groups in the community.
Statement here: the right not to know is exercised all the time. Correct. Okay. Thanks for that, Anthony. Cherie Wax, do you support a federal ICAC?
Well, I think that's an interesting question. I don't think I have a dogmatic view about it. I think all the states and territories now have corruption bodies. New South Wales was the first in 1988, the Independent Commission against Corruption. I'm not sure that there's ever been demonstrated at the federal level the kinds of activities that you've sometimes seen at the state level, but I understand the argument for it. But as I say, I'm not sure that historically there's a great deal of evidence in that area. I suspect it will happen relatively soon, whichever side of politics is going to be in government at the time.
Now, we've got an answer here to a question, but I don't know what the question is, from Barking Madeline, who's I can answer that, the noisy labelling finger pointing lefties. I'm not sure what the question was, but anyway, here's an answer. There we go. Anthony Carr, are not the likes of Twitter, Facebook, YouTube, etc., privatising censorship? That's what I was saying. That's we've already dealt with that, I think, haven't we?
I think we agreed, yes.
Yeah. Is an interesting. Is their label of fact-checking the same as censorship?
Well, theoretically, not. I suppose if you're fact-checking something, you've got to set out what it is in the first place. So, to that extent, the views put forward, and then you might say, well, we fact-checked it and we think it's completely wrong. It seems to me to be quite a legitimate debate to have.
Cherie Wax, what do you think of University of Queensland suspending Drew Pavlou over his organising pro-Hong Kong democracy protests when the uni receives large funding from the Chinese government, i.e. conflict of interest?
I can't talk about the individual case because I haven't looked at it, but I did mention more generally when I was speaking earlier about universities, and it's ironic, I think, that for many centuries universities were seen as places where you could have very open discussion, and they were places where traditionally established ideas were challenged, and so I don't know what's happened this particular case, but I have said more generally and publicly about universities that university administrations in Australia seem to have accepted a lot of political correctness, and that universities are no longer necessarily places where traditional ideas can be challenged. So as someone who was associated with universities for quite a long time, it's just I'm just find it disappointing that universities have not been the sort of protectors of freedom of speech and freedom of idea in recent times, at least in many cases, but they were in earlier times.
Yeah, the Drew Pavley case, I followed it quite closely because we actually were thinking of getting him to do a video stream for us, but it fell through. It really is quite shocking because what happened was in July last year, he organised a demonstration on the campus in support of the Hong Kong people who were demonstrating for freedom. And his little demonstration, it wasn't a large one, was sort of attacked by a mob who of pro-Beijing students who, who were praised by the Chinese Consul General up there. And after that, Drew made a number of protests about this, and the university demanded he stop doing that, and in fact brought in their law firm, Correctness, to prepare a 186-page case against him. And in fact, a couple of weeks ago, they actually suspended him for 2 years. It really was quite appalling. And but the university is so dependent on Chinese student fee income that they don't seem to think they can stand up to this sort of pressure from the Chinese regime. I mean, this is really bad stuff, I think. But, yeah. Stan, so I protest about police to find out never requested being deductive. That's okay. That's kind of a statement, I think. Anthony Carr, but what is the common good? It's a large question.
I think too large in some ways, that's right. Well, we all have our ideas of the common good, but as in terms of the general well-being of the community. But that's really what the political process is all about, identifying the common good.
Right. Okay. We're sort of Michael's going to have to leave quite soon, so people have already asked a lot. I might sort of skip through and try and make sure that we don't miss anybody who's not already asked. Cherie Wax, do you think censorship has gone too far with the removal of Gone with the Wind and Chris Lilly's programs from Netflix, for example?
I always thought Gone with the Wind was a pretty bad movie, really, but that doesn't mean, of course, that it shouldn't be available. I think the most bizarre aspect of the last couple of days or weeks has been the BBC's removal of one episode of at least of Fawlty Towers from their archive. As I say, I mentioned the way in which political correctness has, I think, happened so quickly, at least in historical terms, 25 years or so. And that indicates, I'm afraid, that we're still, the curve's still rising, I think, in this area, and not falling.
Right, where are we? Mulan. Is Zoom infringing on freedom of speech by blocking the activists' accounts? Sorry, which activists? I'm not quite sure.
I don't know. I've had two recent experiences with Zoom, but I don't know how it functions, and who's able to use it. Really, my understanding is that people. Well, I wasn't at all sure whether it seemed to be a free service or whether people subscribed and had to pay for it.
Right. Peter and Michael, should it not be compulsory to publish fact checks beside the claims of political leaders? You got a view about that?
Well, there's occasionally it's said that political statements or statements by politicians, perhaps narrowing it down, should be the subject of or could be the subject of litigation under what used to be called the Trade Practices Legislation, consumer, I think, and legislation as it's now called, false and misleading statements, etc. I think if you introduce that into the political area, there'll be no end of that kind of litigation. Traditionally, people have had to sort this out for themselves, I think, when the competing claims are made by two sides, and I don't think we want to get lawyers involved in those kinds of exercises.
Yeah, but then in addition to that, you end up with what somebody called the neutral epistemic arbiter problem. Who can you trust to be objective in carrying out fact checks? There have been so many cases of fact checkers being so patently biased.
I think the general community's well able to sort those kinds of claims out, really, and I just don't think it's the notion that you'd have this kind of thing in the courts strikes me as completely unsatisfactory.
Now, this one will stump you, Michael. You won't have an answer to this. Thanks all. Is there still a swimming pool in Blackheath that's been overtaken by frogs?
One for you.
Well, I don't have a clue. I didn't know, but thank you for that. Right. There we go. Yeah, Anthony Carr sort of making the point. Sometimes the fact checkers need to be fact checked. I think that might apply to Media Watch. Another question about what's this one? Michael, what do you think about the City University Vice Chancellor's claim that we are moving toward white Australia policy? What's he talking about? Is he rather not a bootlicker for the regime in China financing his uni? Well,
Well, I don't want to comment on individual statements by Vice Chancellor.
As an expert on defamation law, that sounds very wise.
I've made the comments that I have about universities, and as I say, it's a general comment, really.
Right. Well, Michael, I think I know you need to get away, so perhaps it might be a few things coming through, but I think we might wind it up at that point. I'd like to thank everybody who's contributed, and I'd especially like to thank Michael, who is actually in town at the moment, and he was planning to come up here to do the physical meeting, but he's up here and he's doing the virtual meeting from Blackheath. So that's good. So thank you very much, and I will terminate the broadcast at this point. Okay.